and you are most welcome. I do look forward to having an interactive session with us as we learn more. Thank you so much.
Okay. Thank you. Again, you're most welcome. We are already 20 minutes out of our time. Most of the members joined us late, but nonetheless, we shall pick up areas that we shall discuss, and we shall look at the critical areas based on the question that will come from the audience. But quickly, Faith, could you just explain to us the different types of marriage, and you also clarify cohabitation and whether it's a recognized form of marriage in Uganda?
Okay, thank you, Council Mary. Under the Ugandan law, marriage is a legally recognized union between a man and a woman. Marriage in Uganda is governed by specific statutes depending on the form of the marriage that you choose to undertake. In Uganda, the law recognizes one, civil marriage, customary marriage, Islamic marriage, and Hindu marriage, and also Christian marriage. Civil marriage is governed by the Marriage Act. Under the civil marriage, the registrar is the one that conducts the marriage, or a licensed minister of religion acting under that civil authority that has been bestowed on them. Civil marriage is monogamous in nature. That means it's a marriage between one man and one woman. Sorry about that. Yes. Before conducting a civil marriage, the registrar requires a person, or the people intending to marry, to have complied with the formal procedures, which include notice, registration, and finally issuance of a marriage certificate. So this means the man and woman will have to come and give notice that they are intended to get married, and after that notice has been made, they will register them. They need to have to swear affidavits about their intention of marriage. These affidavits are filed, and finally they will be registered and given a date. Once a date is given, they will attend. They'll be attended to by the registrar, and they will be married off and issued a marriage certificate. So that falls under a civil marriage. Also, key to note is that in Uganda, if somebody is getting under the civil marriage, they are required to have a certificate from the country that they come from, a certificate that shows that they are not married in their country of origin. So that is a must comply with when you are undertaking a civil marriage in Uganda between a foreigner and a Ugandan. Okay, that's it under the civil marriage. Under customary marriage, this is governed by the Customary Marriage Registration Act. Under this act, it recognizes that marriages are conducted according to the customs of a particular tribe or community in Uganda. So this means we have different tribes: the Bachiga, Baganda, Basoga, Banyankole. Formally, hold your marriage as customary. Under the Customary Marriage Registration Act, polygamy is permitted. That means a man can have even 5 women, depending on the customs of the tribe. Please note that it's not religion based, it's just that customary marriage is polygamous in nature. A man can introduce a woman today, even the next weekend, and even the next weekend. The only thing that would limit them is their morals. But polygamy is very accepted. Um, for a customary marriage to be recognized under the law, that marriage should be registered within 6 months of the ceremony. Beyond the 6 months, it may not be legally recognized. So for the people that are going down that road of customary marriage, please note that you have a limitation period of 6 months for that ceremony to be uh, legally recognized. So don't sit back and say, "Oh, I did a function. I was married off by this man traditionally, so we're husband and wife," and you lay back. If you don't anticipate uh, to legalize it through a church wedding or a civil uh, wedding, please register the civil marriage within 6 months. So that is very key to note. Okay. So we also have the Christian marriage, which is governed by the Marriage Act. So under this Christian marriage, this is conducted by a licensed minister in a registered church. Something that we Christians usually forget, okay, we don't think about it much, is finding out whether the church we are getting married from is legally registered. If you get married in a church that is not legally registered, rejected, because when they did a background search, the church that she got married from was not registered and they were not paying their tax returns. So she has not been married for 13 years and she did not know that. She was just, wearing a ring, and she had her marriage certificate beautifully framed, not knowing that the marriage that was conducted was invalid. Um, so another thing is this Christian marriage is monogamous in nature. So this means that you can only have one man married to one wife. If you still have a subsisting Christian marriage, you cannot get married until the subsisting marriage has been dissolved by court or by death of your partner. Those are the only reasons as to why the Christian marriage can end. Usually, when you're saying your vows in church, the only way that is when your vows in church, you say for until death do us apart. That is one of the reasons. That is one of the ways a Christian marriage can be dissolved, either by death or by a court order dissolving that marriage. Okay, we'll move on to Islamic marriage. Islamic marriage is governed by the Marriage and Divorce of Mohammedans Act, and it's conducted according to Islamic rites. So, the Islamic rights and the Marriage and Divorce of Mohammedans Act permits a Muslim man to marry up to 4 wives. However, that is if he can treat them equally as permitted by Islamic law. That is why you'll find a Muslim man, a Haji, has 4 wives, but equally he has every wife has their own home, their own car. When he buys a car, he will buy for all the 4 of them. If he's buying houses for them, he will buy for all of them. So you have to be able to treat your 4 wives equally. Yes. The only way that Islamic marriage can be dissolved is by talaq. So talaq is the man or the woman will talaq their spouse, I think 3 times. And that is how a marriage is dissolved under Islamic marriage. We also have Hindu marriage in Uganda. Hindu marriage is amongst the Indian Asians. It's governed by the Hindu Marriage and Divorce Act. It's conducted according to the Hindu customs and ceremonies, and it is also monogamous in nature. Okay, Council Mary also asked me to discuss about cohabiting. Friends, please note that cohabiting is not marriage. If you've lived with a woman for even 20 years, even 30 years, you are not married. You are simply cohabiting. There is a debate in our parliament about whether cohabiting can amount to marriage if you've lived with your partner for more than, I think, 10 years. I stand to be corrected on that. Yeah, I'm not very conversant. Yes, but that is still subject to debate and approval. Otherwise,
So,
cohabiting.
so Faith, in other words, you're saying that cohabitation is not a form of marriage.
No, it's not a form of marriage.
So, what if someone has lived with their spouse for 12 years and in the 12 years they have children, they have built investment? Wouldn't that qualify as marriage? Can someone refer to their person as my husband or my wife?
Unfortunately, not. You can't, even when you've lived for 30 years and um, you've built yourselves, you've amassed wealth, you have children, and your children even have children, you are still not married. Uh, Even in death, if someone has left a will, say uh, maybe someone's husband, God forbid, has passed on, and him and the wife have amassed, this kind of wealth, and they were not married, such a person would only get letters of administration as a friend, and they would also get letters of administration for the court would accept this person to be on the letters of administration just because they are a mother to the children. If they are infants, she can represent them not as a wife, but you are referred to as a friend of the deceased. Lawyers here that have done letters of administration have witnessed this. It will definitely, you are not recognized in law as a wife or as a husband of the deceased. So, friends, please note that cohabiting with a man or a woman does not amount to a marriage. Uh, there is a Supreme Court ruling in Muwanga Chintu versus Chintu. It's a 1983 case that affirmed that mere cohabitation, however long, does not amount to a marriage. Cohabitation does not confer the legal rights and obligations that arise from a a recognized marriage, such as rights to property, inheritance, or maintenance. I will share that case in the messages. However, please note that courts may consider the contribution of a cohabiting partner under equitable principles, for instance, in property disputes. Yes, but this is not the same as matrimonial property rights. So kindly consider, put that in at the back of your mind. Yes, Council Mary, I would like to conclude by saying that only marriages solemnized, and recognized under the relevant Ugandan statutes are valid in law. Cohabitation, though common in practice, it happens a lot. It does not constitute marriage and does not grant spousal rights unless formalized under one of the recognized marriage laws that I have discussed above. Thank you so much.
Great. Thank you very much, Faith. That was very insightful. We appreciate, and I hope the members on the other side are able to jot down these issues. They are very important. We shall be expecting questions from you. Quickly, we have looked at the different forms of marriage, and now I would like to invite Council Anna to take us through um, those grounds for divorce. We are working behind time. Council Anna, please give us the grounds for divorce in brief, because I want to give the audience time to be able to ask their questions.
Okay. Thank you so much, Council Mary, and thank you so much, Council Faith, for that insightful presentation. So moving on to the divorce process. So when it comes to divorce, when you are going to court, you cannot just wake up one day and just say, you know what, I'm just tired of this marriage, so I want out. Our law really does not work like that. Under the Divorce Act, they require that if you are civilly married, if you are married in the Christian through a Christian way of marriage, you need to have grounds for you to be able to go to court and petition court so that court can grant you that divorce. And looking at that act, there are basically three major grounds that one must be able to present while filing that petition, and one of them is what we call adultery. Adultery is in simple terms, it's basically where two people are married and one or both have decided to go and have extramarital affairs, or in our context we call it cheating. Yeah, so you go and get another man or another woman and you start having intimate relationship with that person, knowing very well that you are in our you have contracted a one man one woman marriage that does not allow you to step outside that. And additionally also, adultery can also happen, because this is something that I've seen that happen in our context a lot. um People who are married civilly, or those that are married in church, they go ahead and contract customary marriage. I think Council Faith elaborated on that. That is not permissible. If you do that, actually you commit what we call adultery, because you are not married. That marriage is void, but you've also, in addition to that, you have committed what we call adultery, and it can be used as a ground for the other party to seek divorce, and yes, and petition court on that ground. Then I think moving on, another ground that court also looks at is cruelty. And cruelty basically is any form of abuse. It can be emotional, it can be physical. You're cruel to your partner. You're married, but like you are just there, like you're strangers, you're fighting, you're quarreling, sometimes you even fight, like beating each other. The law does not allow that. So the affected party can actually petition court and ask court to grant them that divorce on that ground of cruelty. Then the third major ground that we can also look at is what we call desertion. Desertion happens in a way that you are not together, you're not intimate with your partner for more than 2 years or more. You sometimes you might even live in the same house, but there's nothing going on. You're like friends. You're like, buddies in a house. There's nothing that show that you guys are together as a couple. So I think the party that is affected can also petition court. And it does not only have to be one. Sometimes you find that one person can be having all these grounds. By the time they're going to court, there are all these grounds. There's adultery, there's cruelty, there's desertion. So you can ask court to what hear your grounds, and if court is satisfied, they can grant it. And I think moving on, we can just briefly look at the procedure, and if questions come, we'll be able to elaborate. But basically the procedure that one needs to know while seeking for divorce in court is the affected party can petition court. We call it petitioning, but it's basically filing your document in court, asking court for divorce, and you list those grounds, right? And once you've petitioned court, court will give you what we call summons, and you serve the other person, because it's very rare for court to handle divorce cases ex parte. They always want to hear both parties. They want to hear both sides. They allow the other party to also file in their defense within a period of 15 days. And once that has been filed, before even you go to court for hearing, they normally refer you for mediation. It's mandatory. They want to see, looking at the Ugandan, I think, context, family is our laws and our principles are basically built on what we call family morals and all that. So sometimes they're going to refer you to see if you can sort it out. But if it fails, then you can go back to court, and court hears. And once court is satisfied, court will grant the parties what we call decree nisi. Decree nisi is basically the first it's divorce, but it's not conclusive. It's they have granted you the divorce, but they're giving you that a period of 6 months, because they know sometimes when it comes to matters of the heart, people fall out, people fall back in love. So the law does allow that. It gives you that period of 6 months within which, in case you decide to reconcile, then you're not yet divorced. You can just continue with your marriage, like as if this divorce didn't even happen. So that is what we call decree nisi. But if that 6 months elapses and there's nothing that has happened, you're still interested in having that divorce finalized, then now court grants you what we call decree absolute, and that is the final. Once court grants that, you are officially separated. You are referred to as single. The man and the woman are both referred to as single, and you can subsequently you can enter into other marriages. Yeah, so counsel, I think that is briefly what I can state in regard to that. I think Counsel Faith elaborated on the other forms of marriages like Islamic. I think they do what we call talak. When the spouses no longer want to be married, you just say talak. But there should be reasons. There should be grounds. You don't just wake up and you say that word. No, you only say it when the grounds are there. And then for customary marriage, in most cases, the separation or the divorce happens in accordance to the different cultures and traditions. Yeah, so, and looking at our African settings, in most cases it's through family meetings where they sit and discuss all this. But also take note that I think with customary marriages, it's also important to know that other issues of property and all that can come in. But I think that we shall discuss it when we come to division of property. But basically, that is what I can say briefly on
Okay,
divorce.
thank you very much, Council Anna. That was another insightful discussion. Thank you very much. And now I would like to invite the audience to ask some questions. You can give us your experiences or anything. In a few minutes, it's 7:47 p.m. We are running out of time. If you have a question, yes, please. I can see Zelinda. Zelinda, you may ask your question.
Thank you so much for this opportunity. I'm really happy that we have this opportunity to hear from the advocates. My particular question is on the third grounds of divorce when we talk about this decision, not intimate for 2 years. How can one give a justification? Is it my word against the partner, or there are things that you're able to show? Because many times that's where individuals get stranded, as in how do they justify that they have been deserted, assuming they're living in the same house. Thank you.
Okay, thank you very much, Zelinda. Council Anne, I hope you've noted that question. Can we take another question? No, Zelinda, you have an okay.
An additional question to Council Faith. We have seen many people who are wedded still go behind their wives and do traditional marriages. And I think, I don't know why this happens, but you find that even when the wives try to sort for legal redress, they are mostly threatened and they end up not getting legal redress. What are the best guidance that can be given to such a person who comes to you? I come from a protection background, and we face many of the survivors asking such questions. So it's good for me to know what are the guidance we can give to such individuals. Thank you.
Right, thank you very much. Faith, take note of that question. You'll be able to answer it. I've seen a hand by Elvis. Elvis, you have a
Um,
question? Yes.
Thank you very much. Thank you very much. My question is, I stepped in late, but I wanted to know how it is done if the man and the woman are of different tribes and different religions. Like, is that accepted to be married, and how is it done? That's my question.
Okay, could you just elaborate on that question, Elvis? What religions are we talking about?
Let's assume one is a Catholic and maybe the other is a Muslim.
Okay, we shall answer
Cause,
that. Thank
'cause, yeah,
you.
'cause- okay.
Faith, that is a marriage question. Please take note. Okay, Julian.
Hello, everyone. I'm Juliana. I'm an advocate as well, although my practice is based on banking and finance. So I would like to know, does stating that you have irreconcilable differences have a bearing in divorce? I might give an example of I married someone in my 20s, and as you know, someone grows. In your 30s, you may be different people, and we just now don't really relate. There's been no adultery, no separation, no cruelty, but we just feel like it's time to move on. Does irreconcilable differences have a place in Ugandan law as a ground for divorce? Then, um, my general knowledge in family law is restricted to LDC, so I would like to know in practice if the petitioner for divorce is intent on separating, but the respondent is not. So how does that ideally play out? I know there are submissions on either side, and ideally, if you don't want to separate, your submissions will be in that line. So, what happens ultimately if I do not want to separate and someone has petitioned against me? Will court not separate us on the basis there were no grounds, but clearly one party wants to leave? Is it that we shall just remain in the marriage, although one person ultimately wants to leave, or can that be a ground to separate? I mean, to divorce the parties?
Okay, thank you, Council Julian. Council Juliana, you said. Council Anna, please take note irreconcilable differences, and if one person wants to opt out and the other does not want, can the court do it even when there are no grounds for divorce? Please take note. Can we have one other question and then the panelists answer? I guess those are Julian, your hand is still up. Do you have another question?
No, I do not. Sorry.
Okay, thank you.
That's it. Yeah.
Thank you, Council. All right, so I'll get back to Faith. You had some questions to answer. Could you please answer them in a short time?
Yes, thank you, Council Mary. Let me recall the person that asked the question. Was that Zelinda? Zelinda, you asked a very excellent and a very important question. Your question was, for the benefit of those that have just joined, Zelinda asked, when there is a subsisting marriage and a man goes ahead and does a traditional marriage with another woman, can how her question is, how can the official legal wife be protected? I hope that was the question that you asked. Okay. So this situation touches on bigamy. It also touches on customary marriages and the legal protection of the first, the lawful wife, under Ugandan law. So let me try and break it down. Um, okay, I'll give you the legal position. The legal position is that the first marriage prevails over any other incoming new marriages. Let me call them incoming. If a man is already in a legally recognized marriage, that is the church, the civil, or the customary registered under the Marriage Act, Customary Marriage Registration Act, and he goes ahead to marry another woman traditionally or customarily, the second marriage is null and void in law. When you look at the different sections of the law, for example, the Marriage Act, any person who, being married under that act, contracts another marriage while the former marriage is still subsisting commits the offense of uh, bigamy. Under the Penal Code Act, bigamy is a criminal offense and it's punishable by imprisonment for up to 5 years. Therefore, Zelinda, and for the benefit of everyone else, the first marriage remains valid and legally protected, while the second union has no legal standing. Second part of the question is, what can the legal first wife do? Firstly, the legal wife can file a criminal complaint by reporting the matter to police or the um, DPP. So the complaint should show proof of her legal marriage, that is a marriage certificate or registration, and then proof that the man knowingly conducted another marriage while still married. Secondly, the first wife can petition for divorce and property rights. That is if she chooses to end the marriage. She can file for divorce under the Divorce Act, citing adultery and bigamy as grounds for the divorce. Then she can also go ahead and claim her share of matrimonial property, especially if she contributed financially or otherwise to acquiring that property. There is a famous case of Julius Rabinomi versus Hope by Himbi Somwe. It's a Supreme Court case that recognized that contribution by a spouse, even when property is registered in the other person's name, is also belongs to the other spouse, the wife. Okay, so in this case, this man did not want to share the matrimonial property after the divorce. However, court said this woman has been cleaning your house, she's been, cooking for you food, she has, added a few decorations to the house. Generally, she has had her hand in the maintenance of the home. Therefore, she's entitled to her claim or share of that matrimonial house. Thirdly, the first wife can also seek an injunction or even put a caveat. That is, if, for example, the man tries to sell the matrimonial property or even evict her from the home, new love. You want to bring in the new, maybe younger wife, I don't know. So the first wife has another option of seeking an injunction from court if the man tries to do any of the above that I've discussed. Sometimes the men want to transfer property to the new wife, so the first wife can apply to court for an injunction, yes, or lodge a caveat on that property under the Land Act to prevent it from being disposed of. The fourth, um, the woman can protect her children and her maintenance rights. So the woman can apply for child custody and maintenance under the Children's Act, and also apply for spousal maintenance under the Matrimonial Causes Act. This can be during divorce proceedings if she wishes to go down that road. So here is the effect on the second wife. The second marriage is void. In the law, we call it void ab initio. That is, it's invalid from the very beginning. So the ladies on here, please find out if the man that you are with is legally married or not. Otherwise, if you go ahead and have functions and all these things, maybe he's telling you that he has gotten a divorce, the divorce has not yet been concluded. Whatever you're doing is invalid. The second wife cannot claim the legal wife rights under the Marriage Act. However, if she cohabited with a man in good faith, believing that he was single, she can only claim equitable rights like contribution to property under common law principles, that is unjust enrichment or constructive trust. I would recommend these following steps for the legal wife if she ever suspects that the man is trying to procure another marriage. First of all, gather your evidence. Get your marriage certificate, your photos, your witnesses from the second traditional ceremony and have them. Report to police, like I discussed earlier. Seek legal advice from a lawyer. That is if you wish to file for divorce or legal separation. Protect your property and maintenance rights. Apply for injunctions if they are needed. Yes, thank you so much. I hope I have answered your question, Zelinda. I hope I have been able to break it down for you well. Thank you.
Thank you very much,
Sure.
Faith. Before you go to another question that was asked, I'll cross over to Council Anna. Council Anna, you had certain questions that had been asked. Could you answer some of them before I go back to Faith to answer the other questions.
Yeah, thank you so much, Council Mary. I think I had about 3 questions. So I'm going to start with Zelinda's question on how do you prove desertion as a ground of divorce. Yeah, so of course it's important when you petition in court for divorce, every ground has to have evidence. You're just not going to, it can never be your word against the word of the spouse, because then most of these divorce cases are always contentious, so they always need that additional evidence. So for desertion, it's actually not very hard to prove. If you have people that you live with in your home, sometimes even children, if they are of a certain age, teenagers of a certain age, and you have maybe maids, you have relatives, you have family members, your family members as a wife, you could be having sisters, you could be having brothers. Those are the witnesses that you can actually take to court, and they corroborate, they can corroborate your ground of desertion. They write witness statements, or they can be interviewed directly in court. So that's one of the evidence that you can bring to court to prove that ground. Then also, secondly, another thing that you can look at is the lack of communication. Sometimes when you're apart for so long, you're texting someone, you're calling someone, they don't pick. It's very easy to get those logs from the different communication centers or network centers, MTN, Airtel, be it whatever it is. You can bring that evidence to show that you have not been in contact with this person for so many years. Even when you try to reach them, they never seem to respond. When you send them messages, there is no response from them. In other words, they have gone MIA, they have disappeared. Sometimes you don't even know where they are. So that can also be another what? Proof of desertion, that you've not been together with that person for so long. And then also, you can also prove by change of address. National IDs nowadays, the economy is somehow advancing, so sometimes it even shows where someone stays. The person has not been living with you for so many years. Their new address is listed as another address. They have been there for so many years. So you can that's just another way that you can prove what? You can prove that separation. Yeah, so I think briefly that is what I can respond to that. And maybe moving on to the second question. I think it was from Council Juliana, whether irreconcilable differences can act as a ground in divorce proceedings. So I think the simple answer is no. Looking at the Divorce Act, there are 3 major grounds, and then we have bigamy, and that there's that ground of converting into another religion so that you can marry, which all proves adultery at the end of the day. So irreconcilable differences cannot stand alone as a ground in divorce, but it can be used as an addition to those grounds that I earlier on listed. So you cannot just say me, like, I'm maybe over quarreling with this person, I no longer want to. No, you have to have those grounds. But then also take note that sometimes these irreconcilable differences can somehow transform into what we call cruelty. Earlier on, I elaborated that cruelty can be emotional, physical. So irreconcilable differences, there's a very thin line between the two. Sometimes it might actually turn out to be cruelty. There could be some fights, there could be some physical violence, and that is what we can bring as ground of what? Of cruelty. But as it is, irreconcilable difference cannot stand as a ground in divorce proceedings. So I hope that answers you, Counsel Juliana. Then moving on to the third and last question. Counsel Mary, you guide. I only noted the 3 questions, but if there's more, then I can come back and respond to. So the third question was in relation to the petitioners petitioned the court for divorce, but the respondent does not want to divorce, and there is no ground of divorce. Now, for divorce, for you to even petition court, obviously you have to have a ground for even court to go ahead and I think schedule that case for hearing. The grounds should be there. Otherwise, they might throw out that case for you know, lack of the necessary requirements you get. So it's important that you have to have the grounds. But also, this also takes me back to what Council Faith earlier on said. Marriage is between two parties, a man and a woman in our context, and they are consented. It cannot be forced. In other words, it has to be consented. So now, if the other person does not want and you are forcing them to be with you, that somehow ceases, it somehow defies what the true definition of marriage is. And in most cases, you cannot force someone to be with. Definitely, they're going to move out and they're going to go and start living their own life. And at the end of the day, you still find these three grounds that I earlier on stated. Someone will move out and maybe get on with whoever and start dating when they're still legally married because this person does not want to divorce them, or the person will go away for 2 or more years, which can still what at the end of the day bring I mean that ground of desertion. But all in all, you cannot come to court, you cannot petition court for divorce without the grounds, but also you cannot force someone to live with you. So there is that balance. But yeah, thank you so much. I think that's what I can respond to that.
Hey, thank you very much, Council Anna. Thank you, Council Faith. Well, that was very brilliant, and I hope the audience is speaking. Faith, you had another question?
Yes, I did.
Yeah, sure. Take the floor.
Yes, somebody asked about how how can you advise someone who is trying to get married to someone who is of a different religion in Uganda. For example, a man is Christian but the woman is Muslim. Yeah, so that's a very practical question. Um, it's one that touches on religious diversity, legal recognition of marriage types in Uganda, and family harmony. I would advise such a couple by first of all helping them understand Uganda's marriage laws. Like I discussed earlier, Uganda legally recognizes five main types of marriages, each governed by different laws: the civil marriage, Christian marriage, Islamic marriage, customary marriage, and the Hindu marriage. So the main legal issue here is the religious compatibility and recognition. If a Christian man and a Muslim woman wish to marry, they cannot legally, it can't legally happen. Why? Because the church requires both parties to be Christian. If the man is Christian and the woman is Muslim, then they cannot get married in church. They cannot marry under the Islamic law either, because the Muslim law in Uganda requires the man to be Muslim, and a Muslim woman is not permitted to marry a non Muslim man. So the best and legally neutral option is to marry under the Civil Marriage Act. Go to the registrar and have a civil marriage. But if you wish to go uh, with according to religion, it will not be legally possible. Civil marriages are handled by the registrar at URSB. You can go there with your partner, notify, have a notice, be registered, and then be issued a civil marriage certificate. That is the only way. So everybody will remain in their religion, but you will still be married until maybe one of the couples decides to convert to either religion. Yes, I think that is only the only and the best option I can give you.
All
Thank you.
right. Thank you. Thank you very much, Council Faith. Um, do we have other questions? In the meantime, time is running out. I just want Faith to give us a brief on child custody, parental responsibility. Talk about parental responsibility and child maintenance. I will pick another set of questions in a few. Members, we started a bit late, so we are going to end our session at 8:30 instead of 8 p.m. that we had earlier talked about since we started late. Please bear with us. Okay, Faith, briefly, parental responsibility and child
Okay.
maintenance.
Thank you, Council Mary. Parental responsibility and child maintenance is provided for under the Children's Act as amended. The concept of parental responsibility is it outlines the duties, the powers, and rights that parents or persons with parental responsibility have towards their children. In our law, parental responsibility is defined as all the rights, the duties, the powers, the responsibilities, the authority which by law a parent has in relation to the child or the child's property, whether the child is born in or outside wedlock. Wedlock means marriage. So, who has parental responsibility? The mother of the child automatically has a parental responsibility at birth. The father who acquires parental the father acquires parental responsibility if he is married to the child's mother at the time of the child's birth or afterward, or he acknowledges paternity of the child, or he contributes to the child's welfare, maintenance, or upbringing, or he obtains a court order granting him parental responsibility. Please note that under the Children's Act, it broadened the father's entitlement, emphasizing that both parents, whether married or not, owe a shared responsibility to the child. So both parents are required to have this child taken care of and be under their care. Um, so that includes providing for their basic needs, that is food, shelter, clothing, medical care, and education. You ensure that the child's safety, guidance, and moral upbringing is in check, protecting the child's rights as guaranteed under the constitution, then also managing the child's property and legal interests, that is where applicable anyway. Yes, in the interest of time, I will not talk about the nitty gritties of each responsibility, but I can give you maybe a few key takeaways of what parental responsibility entails. So both parents share equal and continuing responsibility for their child, regardless of their marital status. So you can't say because I'm not married to you, I cannot take care of the child. That is out. Failure to maintain a child constitutes neglect and it can attract civil or criminal sanctions. So, whether you've had a child outside wedlock, it is your responsibility as a man to continue maintaining that child. Failure to do so, you've neglected the child, and that is why you find women report the men at police because they're not offering them support. Um, so basically, the court's main concern is always the child's welfare. It is not the relationship between the parents. Yes. All decisions regarding parental responsibility and maintenance are guided by we have this paramount principle in law, which talks about the best interests of a child, and that I've discussed earlier: welfare, safety, development of the child, etc. etc. In the interest of time, I will not go deep into it. Yes, but that's what I can say. Thank you, Mary.
Thank you very much, Council Faith. Council Faith is a senior legal associate at TMBEI Advocates, and she has been the theme moderator for this week. She's the one who has been answering all your questions since Sunday concerning family law matters. Thank you very much, Faith. Council Anna, to you, kindly explain to us the principles of property division at the time of separation or divorce. What are those principles that court takes into consideration as they divide the property of the couple? Okay.
Yeah, thank you so much, Mary. So I'll just dive direct into that. Earlier on, Council Faith mentioned that case of Rabinumi versus Bahim Bisomwe. It's actually one of those landmark cases that brought out certain principles that courts always consider in cases of divorce. And one of them is court looks at what we call equitable interest, because once two people enter into a marriage, when it comes to division of property, I don't have to directly do what we call direct monetary contribution. You get, my contribution can be indirectly. And when court is looking at those cases of divorce, they're going to emphasize that and then I think it's also important to note that sometimes this contribution can be 50-50, by the way. The court can decide to award the man or the woman property that they did not directly contribute any money to. They can even award 50 or even more. You get. So court is going to look at that. And then court is also going to consider I think I already somehow hinted on it, the monetary or non-monetary contribution. And in this case, by the way, I think the man was challenging that the wife did not have any right to seek for his property that he acquired, and he was actually insisting that she did not bring any money to purchase that property. But court was like, no, contribution does not have to come in terms of money. How about the time? How about all those house chores she did? How about, when you were away, she was taking care of the children? How about the emotional? By the court even went ahead to look at the emotional support, the physical support. So all those small contributions that sometimes as layman we might overlook, court is going to look into all that, and court will base on that to divide property among the spouses in divorce cases. Courts also look at the economic circumstances and future needs. Take an example. If, let's say, in most cases, in divorce cases, in most cases, it's the men that are always at a higher standing in terms of the economic aspect of it. You get, so court is going to look at how this divorce is going to affect this woman. So if we don't protect her and maybe we don't give her something, or we don't divide property that will protect her interest and the interest of the children, court is going to look at that. They're going to look at that and the future needs. So courts can decide, please note that in most cases, this is at the discretion of court and basing on the evidence that you're going to provide during these proceedings. So it's not always the same in every case. It differs. Each case is going to be looked at basing on the facts that they have. So it's important to note that. But also courts also look at what we call the length of marriage. How long has this marriage been? Someone who has been married for less than a year might not be treated the same as someone who has been married for 50 years. You're married less than a year and you want 80% of your spouse property. Yeah, realistically, you know, it's very hard to prove that. But for someone who has been there from the onset, they have been there, they have built all these things together, it's going to be very easy to give this property 50-50 or even more. So court is going to look at the length and Of course, if you have evidence of the contribution that you've contributed, there are people who are very organized in how they do their things. Every contribution they do it through bank transactions, or at least they have receipts. And in case of divorce, someone comes with, a file, and you're like, as a lawyer, you're happy, those are like the clients. They come and like, this is so easy because the evidence is there, the receipts, the documentation, everything is clearly laid out. So that also does help. And I think it's also important to note, in especially it was also laid out in this case that I mentioned, equality under the constitution, our constitution. So our constitution grants us equal rights. We are all equal, before the law. So when courts are proceeding in divorce cases, they look at that to avoid issues of bias, to avoid issues of discrimination and gender inequality, because sometimes we come from different cultures and different customs, and some of these customs, they look at one gender as in equal to the other. So court tends to avoid that. So when they're doing this, they're going to be looking at this from the equality point of view, and then they factor all these other principles that I mentioned. So Council Mary, I think in summary, that is what I can say in regard to separate division of property when it comes to divorce. Yeah, thank you.
Thank you very much, Council Anna. Anna Acheng is a senior legal associate at TMBEI Advocates. Thank you very much, Council Anna. Council Anna will be taking us to the next theme of the week, which will be land matters. Please stay tuned for quite more interesting legal insights. Do we have questions? I can see Elvis, you have your hand up. You have a question for us, Elvis?
Yes, please, I do. Thank you very much. Um, Council Faith has answered my question about the religious bit of it in family law matters. Without getting into details, I have two questions. Um, you talked of the civil marriage as an option for the couples who are of different religions. I just wanted to know, after getting that certificate of the civil marriage, is it recognized in different places when one is using it? Then the second question is, just like the way it is when it comes to the religious bit of it in family law matters, does that also apply to couples of different tribes, or when it comes to tribes, it is not considered in family law matters? That's all I have.
Okay, Elvis, you're going to elaborate your last question. What do you mean? Could you just kindly elaborate? What do you ask about consideration in the customary setting or about tribes?
Okay, like I wanted to know, just like religion is a very important thing in family law matters. So is tribe also considered, just like the way religion is? For example, if two couples of maybe different different tribes, maybe in Uganda and maybe another tribe,
I think that is
is
okay.
that also considered?
Council
Or
Faith,
if I told you different,
it's okay, Elvis. We've got it. In the
got
context
it.
of customary marriages, is it issue to do with tribe or customs? What is your take on it? Do we have any other question? Okay.
That's all.
Okay.
Sorry.
Any other person? You have any question?
No, that's all I had.
Thank you. Could you, Sonia Jacqueline, are you trying to speak?
Yes, yes, yes. Thank you very much for giving me audience, and thank you so much for this presentation. Now, I'm inquiring, like we know many marriages these days are not as straight as we expect them to be. In the event that a couple has reached a time for divorce or separation, and it comes to the time of division of property, how about the property that, assuming maybe one spouse was doing something secretly without the other one knowing, how can that problem be solved if the one who was doing it secretly didn't tell this other one later on, but the one who was the offended one, actually, who came to learn of the secrets that there are these buildings, maybe there's a home somewhere, apartment somewhere, but she or he has no access to any documents and what. How can such an issue be solved? Thank you.
Thank you very much, Sonia Jacqueline. Council Anna, that's your question. I hope you have noted it. Do we have any other question? Before I call upon the panelists, why do you assert that some marriages are not straight? That's a question from Deogracius. It's in the chat. Why do you assert that some marriages are not straight? Okay, Faith, that is your question. Faith, over to you. You can answer those questions. Council Faye, are you there?
Yes, yes, I'm here. Yes, I will start by answering the question on intermarriage. Um, Intermarriage is marriage between people of different religion, tribes, races. It is not prohibited. Okay. Um, our Ugandan law does not forbid intermarriage. The Ugandan law only sets out different legal frameworks for how such a marriage can validly take place depending on the circumstances. So you can get married to a person from a different tribe, a different race, so long as your parents accept to it, or if you accept to it because you're above 18 years of age. Then you asked about the civil marriage, on whether it is valid. I think that was the question, if I'm to get that right. Civil marriage is recognized in Uganda. If you go to URSB and be married with your partner and given a marriage certificate from URSB, you have a valid marriage ongoing. It is very recognized. It is very advisable for people who are of different religions. So feel free to procure a civil marriage. Council Mary, kindly repeat for me the question on someone that said, why do you assert that some marriages? I didn't get that right. I didn't get that clearly.
Russia, you're on call. Could you please elaborate your question? Why assert? Why do you assert that some marriages are not straight? Russia, you could kindly elaborate that question.
Okay, thank you very much. Why I said some are not straight, because in an ideal situation, by the time you start living with someone and you've gotten married, we expect there to be transparency, loyalty, and everything, like you do everything in unison. But we've come across cases where maybe one partner or one spouse, a spouse has passed on, and then later on you hear, he had actually done this, he had built an apartment somewhere, he had another family somewhere, when you, the actual spouse, the actual legal wife, wasn't in the know. That's why I use the word the sentence not straight. Thank you.
Hey, thank you very much. I think it was a comment from someone. Gracious about that. It's Council. Can you respond to some of the questions that were raised?
I think Jackie, Sonny Jackie, your question is it's not a legal question, but its deeper interpretation of not straight speaks to emotional dishonesty, pretending like all is well, and yet the other person is emotionally detached and acquiring wealth somewhere else and doing their own things. It speaks to financial secrecy. You're hiding investments, properties, or income. You're living parallel lives with your partner. Each partner is pursuing, separate personal agendas. There's lack of openness, no shared financial vision, no teamwork. So it's not a legal issue, but more of a moral and relational one. A marriage where trust and transparency have broken out. So basically, for a situation like that, if you are a legal wife and you realize that your husband maybe is amassing wealth without your knowledge, be comfortable knowing that you are the legal wife. In case of anything, all that property falls back to you, as long as he procured it within a subsisting marriage. Yes.
All right. Thank you, Council Faith. Council Anna, are you there?
Yes, Council, I am here. So I had a question, and it was in relation to hiding of property by maybe one spouse in during divorce proceedings. Yeah, this is something that does happen, unfortunately, and but legally there's a way around it. As a spouse, if you suspect that your partner is hiding property, that should be brought before the court so that court can fairly distribute those property amongst the spouses. Um, the affected spouse or the petitioner can actually ask court for what we call a formal discovery. Court will issue out an order requiring it's a court order, and they'll issue it to that spouse to basically declare everything that they have. And the same court can also go ahead and give you court order where you can go to lands, the different divisions of land, because by the time that you're suspecting, you could be having an idea what that person is hiding. So you can go to the Ministry of Land. If the property is registered, they can actually do that discovery, and they can clearly declare to you that these are the properties that are registered in the names of so and so and so. And then you can go to the bank can give you financial statements to also declare the amount of wealth. And nowadays banks actually interlink. There's Council Mary, maybe you support me there, but I think there's a way these different banks coordinate that what is in one bank, the other bank can know. For example, if you borrow a loan from one bank, you go to another bank, you cannot hide it. There's a way, there's that communication, and I think it's regulated by the Bank of Uganda. So it is very easy to find out the wealth, the financial history of a person from the financial institution, the different financial institutions. So you can request court to grant you the court order so that you can do that discovery or interrogatories, and they can put that person under oath to declare, because you know that if you lie under oath, that becomes an offense. So basically, to respond to your question, yes, you can ask court, and court can help you in discovery of the different properties, so that by the time you're going back to court, everything is brought on what on everything is out, and the division can be fairly the property can be fairly distributed amongst you two. Yeah, so briefly, that is what I can respond to that question.
Okay, thank you very much.
Thank you
Thank
very
you.
much.
Indeed, you can get a discovery order from court and you get all the information you need from your husband. Phoebe asked a question: who can ask for the letters of administration and all the necessary procedures one can follow to obtain them? I could answer that. We are running out of time. But Phoebe, letters of administration are issued where someone dies intestate. In other words, they have died without a will. And under the Succession Act, a surviving spouse can obtain the letters of administration, the children, and they discussed whether legitimate or illegitimate. They are all children, and so they are entitled to obtain letters of administration. If the surviving spouse is not there, the children are not there, the parents of the deceased can also do that. Brothers, sisters, next of kin, anybody, by the way, can obtain letters of administration as long as you prove that you have the potential to administer the estate of the deceased. Requirements, it's such a lengthy process what you need to obtain, but you must have a death certificate. When someone dies, the first thing you do is to obtain a death certificate, and of course you will need an LC1 chairman's letter who confirms the death and the residence of the person. You must identify all the known beneficiaries. In most cases, they reveal them at the burial. The children of the deceased come out, the spouses come out. Spouse, you must be a legally married, either woman or man. They've discussed the different forms of marriage. If you don't fall under the category that Council Faith discussed, you don't qualify as a spouse to the deceased. So you must be legally married. Identify the properties, and then once you have the letter from the LC chairperson, you will now move to a file for the letters of administration. You have to have a meeting. You have an application made to the Administrator General, who will then invoke their powers. They can sit and have the meetings, or they can forward you to the COW, the Chief Administrative Officers, and you have the meetings. The process is continuous up to the point you receive a certificate of no objection from the Administrator General. So that process that I just skipped because of interest of time, there are meetings that are involved. The COW will have meetings with the family members. They will consult, they will identify the property and confirm really that the people who are claiming are rightful persons to have that property. Then you'll have to have an application or a petition to court, depending on the value of the property. The petition can be to the magistrate's court if it's a small estate, but if it's a big estate, then you have to apply to the High Court. And then before you make your petition, the certificate of no objection is advertised in the newspapers for about 14 days. In case no one comes out, then you proceed and go to court. So briefly, that is the discussion. We can have one last burning question as we conclude. Just one. If the question is not there, then I would wish to thank you all for attending. This is TMBEI Virtual Helper. We have weekly sessions and discuss different matters. I wish to thank our theme moderator, Faith Rinda, advocate. She was the voice behind all the questions and answers that you had throughout the week. Thank you very much. Council Faith, with the support of the TMBEI team. Council Anna, special appreciation to Ashri, our IT personnel, who made sure that everything goes well. Social media, the website, this meeting. Thank you very much. Our researchers, Daniel and Edith, we appreciate. Thank you. Gift, our support team, and Bay Investments Limited, our sponsor. Thank you very much. To the rest of you, I wish to thank you and appreciate you. Thank you for joining. Next week, we shall be having land matters. The whole of next week, starting from tomorrow, Our discussion is on land matters, and we shall crown it with another Q&A session next Saturday, same time. Let's keep time. Let's invite a friend, and let's like and share all the social media pages. Thank you very much. I wish you a blessed weekend, and bye-bye.